Welcome to this presentation on how to write the CIPD Level 5 ECJ Judgment Post. You can visit our website by clicking on link provided in comment sections or chat with us on WhatsApp on clicking link to get best expert help. You will find how to write this question in this video. Kindly subscribe us to and message us on. To begin with, it's essential to understand the legal framework post-Brexit. Before the UK left the European Union in 2020, it was fully subject to the jurisdiction of the European Court of Justice, ECJ. This meant that ECJ rulings were binding on UK courts. However, the UK-EU Withdrawal Agreement and the European Union Withdrawal Act 2018 significantly altered this landscape. ECJ judgments made before the end of the transition period, 31st December 2020, still carry persuasive authority and remain retained EU case law. These can influence current legal decisions, but UK courts are not bound by new ECJ decisions post-Brexit. This marks a significant shift in how case law is interpreted and applied. Understanding this context helps in assessing which ECJ rulings still hold sway and how the UK judiciary can now exercise more independence in its legal interpretations, shaping domestic law in a way that best suits the UK's unique legal and political environment. Currently, ECJ judgments made before the end of 2020 are classified as retained EU case law. This means they still hold legal weight in the UK, especially for matters rooted in EU-derived legislation. Lower UK courts are generally bound by these rulings unless a higher court, such as the Supreme Court or Court of Appeal, chooses to deviate from them. However, these higher courts must provide strong reasons for departing from retained ECJ decisions. Meanwhile, judgments made by the ECJ after 2020 are no longer binding. Nonetheless, they may still influence UK judicial thinking where relevant, especially in areas where EU law remains embedded in UK regulations. This distinction is critical for legal professionals, policymakers, and businesses alike, as it determines whether to rely on previous European jurisprudence or prepare for a potentially divergent interpretation by UK courts, impacting compliance strategies and legal forecasting. An illustrative example of retained ECJ law is the CIMAP judgment, which interpreted working time under the Working Time Directive. The case established that time spent by doctors on call at the workplace counted as working time. Before Brexit, UK courts adopted this principle, especially in NHS employment disputes. Even after leaving the EU, this interpretation still influences UK case law involving similar facts. However, it's important to note that while CIMAP remains persuasive, the UK Supreme Court now holds the power to depart from it if justified. For instance, changes in national workforce strategy, public sector funding, or legislative reforms could provide grounds for reconsideration. This example illustrates how legacy ECJ rulings still shape domestic legal arguments and employment standards, requiring ongoing awareness and adaptation by HR departments, legal advisors, and government bodies tasked with policy implementation and judicial review. From a strategic standpoint, businesses need to be cautious and compliant. Despite Brexit, retained EU case law, such as earlier ECJ rulings, still informs many legal standards, especially in sectors like employment law, consumer rights, and competition law. HR policies should reflect retained legal interpretations to avoid litigation. Furthermore, as UK higher courts gain discretion to diverge from ECJ precedents, organizations must monitor evolving judgments. Legal teams should conduct periodic reviews of current case law and align internal procedures accordingly. Regulatory frameworks could also shift to reflect UK-centric priorities. Staying updated with government announcements, consultations, and legislative changes is vital. Businesses should develop proactive legal strategies and training programs to ensure compliance and adaptability in this changing environment. A lack of awareness or delay in updating legal practices may result in penalties or reputational damage, particularly in regulated industries such as healthcare, finance, or public services. In summary, although Brexit marked a significant legal shift, Judgments made by the European Court of Justice before 2020 remain influential in UK law. Lower courts are typically bound by these unless a higher court chooses to depart from them. Meanwhile, post-2020 ECJ decisions are not binding, but may still carry persuasive weight, depending on the context. For legal teams, the key is to maintain vigilance. Regular policy reviews, legal updates, and alignment with new UK interpretations are essential. Businesses should not assume that EU case law is now irrelevant. It continues to guide interpretations of retained EU law. Advising leadership accurately requires not only legal knowledge, but also strategic foresight. Offering real-world examples and timely updates will ensure compliance and help the organization navigate the complex, evolving landscape of post-Brexit UK law. Forward-looking legal strategy is crucial for risk mitigation and long-term resilience.